Good morning, everybody. Today's session, which is part of a long series of principles podcasts, is about acting fairly and the second part of what acting fairly means in public law as far as adult social services is concerned. Today is about the obligation to address the evidence and stating or giving reasons. Last week, we looked at the first part of acting fairly, which was about not being biased and hearing the other side, actually giving a person a chance to tell you their story and address it. And this week, we're going to be looking at the obligation to give reasons when local authorities or ICBs make decisions. There's a few cases on this, and I'm going to be talking about Sava because that's a Kensington and Chelsea case, whereas I've already talked about the Cambridgeshire case and the Merton case. Cambridgeshire is an ancient case about how specific the calculations have to be and the reasoning underpinning the calculations for a person's personal budget. And that local authority won that case, but not because they were good, but because by the end of the case, enough had been extracted by them by tooth and claw for them to be able to say, now you do all know why we added the budget up in this particular way. So that was one of those cases which, although the council won it, it was actually a really strong indication as to practice not being good and what a council would have to do in order to get plaudits from a local authority. Merton was a case we've spoken about before to do with reassessing. And it was a case where the local authority simply couldn't explain how it had come to the decision that a gentleman who'd been somewhere for a very long time magically no longer needed something in order that his needs be regarded as met. And so that's the context of today. I've wanted to save time, so I'm just going to talk about reasons more than anything else. So what is this duty to give reasons? I have done some looking up and found a bloke called Paul Daly, who's a well-renowned administrative lawyer. And he said this, and I've never really thought of it this way. He said, the best way to understand contemporary administrative law, modern public law, is that what the courts are doing is striking a balance between the values of the idea of the rule of law, good administration, democracy, and the separation of powers. Now, those are all high-flown constitutional principles, and I'm not going to try and turn you into first-year law students, but you will have heard about the rule of law, the idea that we're all under the law, even the king, for instance. I'm sure you all know the difference between good administration and bad administration. And generally, the ombudsman is where you would go to for a decision on that distinction. We all have different ideas of democracy, but in the constitutional context, it's that Parliament produces our laws. And yes, the government drives them, but Parliament produces our laws, and a law ain't a law until it's gone through Parliament. And the separation of powers is the idea that if you have government, Parliament, and the judges, they all operate as checks and balances against the other, and that you have to hold the three in a good balance. So that's what administrative law, public law, is all about. And I want to talk about how the duty to give reasons, if one is a public body, that duty to give reasons is a key example of how we hold that balance. So if you imagine that there's a law, or even just an expectation from the guidance, or even the risk of having to share your reasons if you're sued, it makes all council and NHS staff think much harder about the facts and about the decisions that they've got to make. So first and foremost, it makes for better administration. And that's true for any legislation. But imagine if you're talking about welfare law, who gets housing, who gets education, who gets social services, who gets health. If people have to get over hoops and hurdles as the gateway to getting something that's paid for by public money, and they're turned down, crucially, it's important that they're given reasons. Otherwise, one could have no faith in the administration. And when we talk about society unraveling because it seems that he who shouts loudest gets the most, that's the kind of thing that we're saying at a gut level seems to be wrong. So the content of the legislation itself, who gets what, and how much of anything is enough to give ill and disabled people a good life, well, that's where politics and democracy come in. Because the Care Act has been voted on by Parliament, and the people who made it into Parliament are our MPs. And we elected them, and we trusted them to put through legislation and then theoretically finance the duties that were in the legislation. If that hasn't turned out, then that's how social care ends up unraveling and starts to disappear from the fabric of our society. But ultimately, reasons given by public bodies have to be considered by judges in the cases that get to court. And here's the great thing: the judgments that come out of the cases as to what is a good enough reason and what isn't, well, they feed back into the rules that are binding on all other councils or ICBs. And that in turn improves administration for everyone. So I want you to think of the duty to give reasons as really lying at the heart of public law. And I want now to consider whether there is a duty to give them only if it says so in the Care Act, or for instance, if it says so in the guidance. And then how good do those reasons have to be lawful reasons? We've all, haven't we, ended up saying to our children, enough is enough. Don't ask me why anymore. I'm just telling you, you've just got to accept the decision. So really what I'm interested in having you think about is that the legal principle here that matters, you have to believe me, because I'm sticking my reputation on the line here, it doesn't actually have to say so anywhere in the law that there's a duty to give reasons before such a duty arises. And if social workers were taught that from the beginning, our lives would be very different, wouldn't they? The duty to give reasons can arise because a law says so or the guidance says so, but actually, even without, it arises from the context. And here the context is who gets what from social services and how good is our health service. So social services and health professionals' attention, it's absolutely central to people's well-being and functioning. And the courts have said, therefore, that the reasons for the decisions as to who gets what are really compelled by public law itself. Even if you've got an officer waving the Mental Health Act at you, or the Code of Practice, or the Care Act, or the NHS legislation, and saying to you, you can't be right because it doesn't say that we've got to give reasons. It's important to be able to say public law makes you have to give reasons. How good do these reasons have to be? Well, the law says that reasons, when they are required, have to be intelligible. That doesn't mean intelligent, but they have to hang together. They have to be adequate and they have to be proper. And they must enable the reader to understand what conclusions were reached and why on the principal, important, controversial issues. So not every I dotted and every T crossed, because administration would get clogged up if social workers had to be like lawyers in terms of their decisions, but at least coherent, adequate and proper, and not written afterwards, for instance, to suit the problem. And the courts have settled on this overall formulation when looking at reasons to see if they hang together. The question will be whether the information so provided by the authority leaves room for genuine doubt as to what it has decided or why. So that is the kind of standard that you're looking for out of public authorities. And I think that that makes sense to most people. So if I go back to a social care case involving Kensington and Chelsea, the court had said this. The argument had been over the resource allocation system and whether the figures that had been offered every few weeks or so to Mrs. Sava for her package hung together. Did the reasons for the increases make any sense at all? She'd not been given any explanation. She hadn't been able to understand whether she was being given more points, which was generating more money, or whether she was being given more pounds for her existing points. Were her needs being broadened? And that was what was driving the increase in the budget she was being offered. So the judge said to the lawyer acting for Kensington, everyone agrees that there's no general duty to give reasons, but that the context does require them. Kensington and Chelsea said a good old social care budget surely isn't one of them, but the judge did not agree with her. And he said this, just as in all three of the cases referred to, the defendant has specific statutory duties. Just as in all of the cases referred to, the council must comply with these duties in a transparent way, explaining with sufficient clarity that their decision-making is evidence-based. And I don't accept the barrister's submission that just because the direct payment scheme is an ongoing process requiring a continuing dialogue, it's okay for the reasons to just be reflected in the care plan and communicated to the service user via the social worker and the support broker later. He said absolutely that that's not good enough. And the reason he said it wasn't good enough was found in the guidance that was in place at the time, called Putting People First. This was guidance issued not by the government, but by ADAS themselves, the Directors of Adult Social Services. And I can only applaud them for having written it, because it meant that Mrs. Sava won the case. The guidance demonstrated a clear policy to provide all service users with transparent information about how budgets were being arrived at. And there is this common law duty under public law to provide evidence-based reasons anyway, if it's an important enough area of people's lives. And the judge said this, if a local authority were just entitled to notify a bald figure without any explanation, the recipient would have no means of satisfying himself or herself that it was properly calculated. The guidance explains that the reasons make it possible for people to challenge these decisions. And without reasons, there would be no possible way of mounting a challenge, either by way of complaint or by way of litigation. So the next time you're involved with people who need help in challenging their budgets, can you see why, if the matter came to us, the first thing we would say is this: have you got any idea of the reasons? Have you asked for the reasons? Have you chased the reasons? Have you cited any guidance or law to the local authority, making it clear that you are entitled to reasons? And the judge said, it must be incumbent on those responsible for this kind of service to be transparent and to explain individual decisions in a precise and clear manner. And the judge went further and he said, it's not good enough for the panel to just hand off the reasons to be given to the responsibility of the poor old frontline worker. The judge said it is for the panel to provide or approve the reasons in a document. Any other means of communication is just going to cause Chinese whispers. So we're talking here about an era in which you had panels made up of very wide spectrum of people. For instance, the finance director for adult social services would be sat there on the panel. These days, we understand that panels have got to have people with social work credentials on them, although it can go wider. But the reason that that's happened is because of this case. It is for the panel to provide or approve the reasons. And as you know, the reasons have got to be defensible. So that's really good. A leading case on reasons comes from housing law, and I'm hoping I'm pronouncing this correctly, as Zolomiso. And this is a case involving a Supreme Court decision about how strict they're going to be about the reasons. And it indicated a general strengthening of the judge's requirements of local authorities. Courts are not prepared to make assumptions in favour of a public authority and simply infer that good reasons exist in the absence of evidence. And ever since Zolomiso, which was in 2015, courts have been more astute not to let local authorities immunize their decisions from judicial scrutiny by just being blunt or bald about their decisions. The case doesn't matter in terms of what it involved, but it was an argument about housing and an offer to accommodate a lady a very long way away from where she was living. She was living in Westminster, and the housing authority thought it would be a good idea to send her to Milton Keynes. And they argued about it, and the reasons were given in a very limited and standard form, just referencing finances and the housing market, and literally just repeating to this lady, all relevant considerations have been taken into account. And the court found those to be inadequate. And Lady Dame Brenda Hale in the Supreme Court said, "It must be clear from the decision that proper consideration has been given to the relevant matters, including precisely how the relevant provisions of statute and departmental guidance had been taken into account." Now, unless advocates and members of the public know about that being the requirement, asking for reasons isn't going to get them anywhere. They've got to be able to look at the reasons and work out whether those reasons hang together defensibly. Even if they don't agree with them, what a person is making a judgment about when they decide to go and take legal advice is that the best will in the world, the reasons they've been given, just don't make sense. So out of the Zolomiso case, housing law commentators basically gave advice to housing officers. And I've put some of this advice here because it's interesting. I personally think that this could apply to adult social care too, but the culture is just not the same. So the housing expert said, in the wake of Zolomiso, each council should have and keep up to date a policy for how it procures sufficient units of temporary accommodation to meet anticipated demand during the coming year. You could say the same, couldn't you, for local authorities doing social services provision? They know roughly what they're expecting to have to provide. So what is their policy for procuring sufficient units of it? The policy should reflect the statutory obligations under the Housing Act and the Children Act. And we would say, wouldn't we, the same? We would say adult social care in the Care Act. It should be approved by democratically accountable members of the council, and it should be publicly available. Well, hear about adult social care policy as well. Each council should have a policy for allocating the units to individual homeless households. And if there is an anticipated shortfall of in-borough units, that policy would explain the factors that would be taken into account in offering households those units, the ones that would be taken into account in offering units close to home, and the ones that would make it suitable to accommodate a family further away. And that policy too should be made publicly available. Now, this is an example of how housing law doesn't jump to adult social care law. And that's because people like me, who are an adult social care professional, we tend not to look at housing law. We stick to what we know. But doing these podcasts is making me raise my game about how I can pull in principles from equality law, human rights law, and housing law and NHS law in this particular context. I've also been finding some interesting things from academics about the duty to give reasons. And this chap here, Mark Elliott, is talking about something that is a big problem in public law. A few years ago, the government decided that public law was getting a little bit too muscular and causing aggravation for local government and public bodies generally. So they did a review of administrative law and brought in a principle. It didn't get any newspaper coverage. Nobody thought it was an important thing. But they brought in a new law that said this: you can win a judicial review. The judge can agree with you that what's gone wrong is unlawful. But the other side, the public body, can say to the judge, would you please consider, in fact, you must consider, whether in fact doing the right thing would have made any difference at all. If it's likely that it wouldn't have made any difference and the same outcome would have applied, then the judge is banned from giving a remedy. So just to run that by you again, you can have the law on your side, you can go through all of the hoops and hurdles about getting legal aid or winning a case, and the judge is completely in your favour, but then the other side reminds the judge that there's a new law that says, oh, by the way, if behaving lawfully was highly likely to have made no difference at all, then the winner becomes the loser and the judge can't give a remedy. Now, Mark Elliott very properly says that is an extraordinary piece of law to bring in because it is protecting unlawful decision making. So I'm not expecting you to go and get a PhD in that, but basically the judge is talking here about a new bit of law that came in 2015. And he says that the effect of this is that the High Court is statutorily barred from granting a remedy if the outcome of a decision-making process is highly likely to have been unaffected by a flaw committed in the making of the decision, even though the flaw renders the decision unlawful. And he explains what he's talking about, and then he goes on to say, but let's not panic. It is far from a foregone conclusion that that new statutory ban will work out the way the government expected. And he, because he's a public lawyer, thinks that that is a good thing. And he goes on to explain the risk. And then he goes on to say that, in fact, there is a good argument that it shouldn't happen in terms of giving of reasons. And he basically says that if the legal flaw that's happened that makes the thing unlawful is that the problem is with the reasons that have been given, it's going to be easy to persuade a judge that the failure to give reasons or the giving of bad reasons is such a fundamental flaw that the judge is not going to have to decide that doing it the right way would have made no difference. And he goes on to explain that in terms of the qualitative difference of a reasoned decision compared to a decision for which no adequate reasons are given, or no reasons at all. And guess what? I've got a social care case for you where that man was proved right. It's a case that we've looked at before, a recent case where Croydon said 35 hours had been enough for a young woman during the holidays when she was at college for the rest of the time. And even though if her parents weren't there, she would need 96 hours a week of care when she wasn't at college, the council was still going to give her 35 hours a week when college had finished. And the argument was, give us the reasons, involve us, talk to us about what we're willing and able to do as the parents, and then we might have a way of narrowing the gap between the 35 hours that we accepted before, but that was because our daughter was going to college, and the 96 hours that would be needed if we didn't exist at all. Engage with us. And Croydon was found to have acted unlawfully, and Croydon came forwards with that highly unlikely that it would have made any difference argument, referring to the law brought in 2015. And I am delighted to say that the judge made very short shrift of it. Croydon raised this point, that it appears highly likely that the outcome for the claimant would not have been substantially different, even if the conduct Croydon was guilty of had not occurred. The judge said, I do not consider that that applies in this case, or that there is any other good reason to refuse to grant the remedy. There's no material which supports Croydon's contention that it would have made the same decisions, even if it had involved the claimant and her family, as it should have done. The argument sits very uneasily with the Croydon's other submission about a remedy, which is that all they need to do is offer her a reassessment. That is rubbish too. And the judge said this, Croydon has argued that the family and they were so far apart, they would never have made an agreement. There was no chance that that gap would be resolved by agreement, however much talking was done. And the judge says that may be correct, but it does not support the case that the defendant needs to meet, that the failure to involve the family in the relevant decisions is highly likely to have made no substantial difference. The test is not whether there would have been an agreement, but the test is whether proper involvement would have made a difference or not. The highly likely standard of proof is a very high hurdle for the council to make. The court cannot possibly be satisfied that it was highly likely that the care plan wouldn't have been substantially different if the family had been properly involved. In fact, insofar as I'm allowed to say at all, the judge said, I actually consider it highly likely that proper involvement of the claimant and her family would have made a substantial difference. And ultimately, the judge says the important stuff for everybody who's arguing about Care Act reasons at the end. The judge says the need for the claimant to be involved was required in this case, not only by general principles of fairness in public law, but also by the particular regime created by the Care Act. This is legislation concerned not just with the objective of promoting physical and mental health. It reflects Parliament's concern to give them the kind of autonomy that is associated with their being able to exercise control over everyday life. Seen in that light, an outcome decision made about a person who's entitled to care and support under the 2014 Act, which fails to involve her or her family in a meaningful way so as to provide that autonomy and control, is itself substantially different from a decision that does achieve doing that. So that's an example of how I think that judge has read that article by that academic public lawyer. And although this might not seem practical for ordinary people to engage with, I'm aiming to bring about a change of culture whereby social workers are properly trained that this is the responsibility of their bosses before they go out to practice and are arm locked into practicing in an unlawful way. It's only decisions like this that keep public law thriving. So I thought that what I'd show you now is where in the Care Act it says that reasons must be given. I found 3 examples. One is in section 7, where the duty to cooperate is being used. And it's possible for one body, like a council, to say to its ICB in the NHS, the Integrated Care Board, we'd like you to cooperate with us in this particular way. If you're going to refuse, the law says, you must give us written reasons for the decision. So, for instance, if I was trying to cooperate with GPs in the NHS and they weren't ever coming to safeguarding meetings, I would be pointing out to them that they need to provide the local authority officer with written reasons for their decision. And I bet you then that they would think it was far less problem to come and do their bit. I'd like them to be asked to give written reasons as to why they won't give mental capacity decisions for the purposes of lasting power of attorney. I'd like them to say in writing it's because they're not paid to do it. And I think that fewer of them then would then refuse people an MCA certificate. The other main example is in section 13, where after an eligibility decision, the reasons must be given for the eligibility determination, whether it's in favour or whether it's against. And the last example is section 24.2, which is a care planning section. And it says, if a local authority has carried out an assessment, but is not required to meet any of the needs, in other words, there are no eligible needs, and it does not decide to do so under its power, it must give the adult concerned written reasons for not meeting the needs. I would be willing to bet that there are 150 councils in this country not abiding by section 24.2 of the Care Act. Even I am surprised at its scope, but it is saying that in any case where it's going to walk away from someone, it has to put its written reasons down for not meeting the needs. And I think that that's very useful, but the next few slides will be even more useful. Because I've done an electronic search on the Care Act guidance and have found, I think it's 7 examples of explicit references to the giving of reasons. Failure to agree a care plan or a budget. Paragraph 1086. In the event that the plan cannot be agreed with the person, the local authority should state the reasons for this. The second example is declining a direct payment. Where accepted, the decision should be recorded in the care plan. Where refused, the person making the request should be provided with written reasons that explain the decision. As an aspect of declining a direct payment for any other reason, the guidance says at paragraph 1222 that the reasons should be given in a format that is accessible to them. And so that is insisting that the disability of the person must govern the way the reasons are stated. Declining a request for a review. The guidance says the local authority should set out the reasons for not accepting the request in a format accessible to the person, along with details of how to pursue the matter. And then finally, in terms of safeguarding, whatever the course of the safeguarding action, the professional concerned should record the concern, the adult's views, the wishes, and any immediate action that it has taken, and the reasons for those actions. So my challenge to you, if this is making sense to you, there's another one, refusal in the face of the duty to cooperate, but that's the one we already looked at, and refusing a transition assessment. It must provide its reasons for this in writing, and that's when a young person wants to have a transition assessment. Now, my challenge for you is try to do the same on the National Health Service Framework for Continuing Healthcare. You can get that up online. There's the link for it. And there are 26 instances of the word reasons in that document. And then you'll be equipping yourself with the means to say to an ICB that, in fact, it does say in the framework that reasons should be given. And the last couple of slides I've got before we open up to questions, this is from a Court of Protection case, which has just been reported about a very, very sick man with severe learning disabilities and in need of a kidney transplant. He's at end stage renal failure, and the Court of Protection had to consider whether putting him through the operation with sedation afterwards was in his best interests. The experts gave evidence and suggested that it would not be in the man's best interests. And the judge was very impressed by the care and consideration shown, and he didn't have any criticism of the experts, but he said this: the expert advises the court, but the judge decides. An expert is not in any special position, and there's no presumption of belief in a doctor, however distinguished he or she may be. But it is necessary for even the judge to give reasons for disagreeing with experts' conclusions or recommendations. A judge cannot simply substitute his own views for the views of the experts without some evidence to support what he concludes. So the message I want to give you is that holding the NHS and local authorities to account, which is all public law can ever do, actually turns on engaging with decision makers about their reasons and being good enough at language to be able to spot a load of rubbish reasons. Now, the remaining slides in this PowerPoint is a shocking thing to be showing you. These are cunning suggestions to local authorities from legal experts, again in the housing field. And the expert has got a conference probably or a webinar going where local authority housing officers need to be taught how to give reasons. So the expert says, what are we trying to achieve? Well, we need to explain to the applicant why they've lost their case. We need to reflect on arguments. We need to weigh up the arguments. We need to analyse how the applicant's argument for housing is structured. And we need to take apart what they are saying if we are going to defend our judgment. So the expert says, statement in an argument that provides a reason or support for the conclusion, that's the premise of the argument. And the conclusion turns on whether you've been able to pull apart the argument or and present an alternative. So the advice goes on to the applicant, the advice goes on to the housing officers as to how to write their decision letters. And it gives examples of the kind of language that local authority staff should use if they're going to survive a judicial review, if they're going to have their opinion upheld as at least defensible. And the expert's view on reasons, in terms of how far they have to go, is that they can be stated briefly and simply. It doesn't have to be a book. A benevolent approach could be expected by the court because housing officers are not lawyers. The reasons need not be elaborate or stated with judicial exactitude. They shouldn't be treated as if the housing officers are construing or composing statutes, contracts, or judgments. And they should not be subjected to pedantic exegesis or exegesis. I'm not sure how I pronounce that. A benevolent approach should be asked for from the court. And that the reasons can be understood by reading the decision letter or even more than one bit of paper together as a whole. And finally, and most importantly, not every factor which weighed with the decision maker on their mind needs to be identified and explained and listed and T's crossed and I's dotted. The key thing is that the issues which were vital to the conclusion, and only those, are identified, and the manner in which the debate was resolved is explained. So I'm thinking that if that's all the courts require of officers in the housing department and social care, it's a measure of how to decide whether you should take your issue to the complaint service or you should take your issue to court. If the reasons do not do what's on that screen, then they are strongly judicially reviewable. But if they meet this test, then probably the local authority will have gone far enough. And so that brings me to my usual end of slide. And I'm interested to know whether anybody's got any questions that they would like to put to me whilst we're still in the session. As usual, we've gone past the time, but has anybody in the session got an example of the kind of case where they have just been blanked and the reasons have not gone far enough as far as they were concerned? If anybody's got an example, I'd be prepared to stick my neck out as to whether the reasons were good enough, because it's what we do all the time. We tell people whether they've got a complaint, a referral to the monitoring officer, or whether they've got an irrational decision that is likely to be judicially reviewable. Anybody want to try one? I see some old faces in the list of people, and I know that they know their public law because they've done courses with me. So I'm wondering if anybody would like to say anything. Please don't be shy.
Hello.
Hello, who's that?
Michael and Sheila Jarvis.
Hello, Michael. Have you heard from the Ombudsman yet?
No, which is why I've clicked. I mean, we've listened. Unfortunately, we missed the start, but we've got enough out of it to realise that everything you've said we've been through. We were blanked. We've been given no reasons. So we went to the complaints department, but the complaints department within Essex is a precursor for the legal department. So we got support, legal support. We went through that argument. We got some resolution, but not total resolution. So we went back and said, we're going to the Ombudsman. So we still wait. And the case is with the Ombudsman. We've said we've got a communication of 10 days ago saying it'll be 5 to 6 weeks until we get a decision. But I think the point of it all is that in the meantime, life has to go on. So whilst this case, our conflict started in December 21, whilst this goes on, we still have to review what's happened with the direct payment package in the interim. And the local authorities still continue to blank us.
Okay, so having listened to this particular session, do you think if you were the ombudsman, in receipt of the complaint that you have made to them, but the ombudsman looks at the reasons that Essex gave you, either at the complaint stage or from the legal department, because you haven't sued them, have you? You haven't gone ahead to judicial review. Not this time around. No. If you were the ombudsman, and the ombudsman is a bit like a court, a bit like the judicial review court, although not a judge, do you think that you would say that the reasons Essex gave hung together? Now, I know you are obviously biased, but now you know that the test is an arm's length one, and that the reasons have only got to be just about good enough. But they still do have to cohere and hang together. What do you reckon?
I reckon that we still have a reasonable chance because Essex have not given coherent reasons.
Okay.
They've given opinions, spotty bits and pieces. I need to be careful how I say this. At one stage, they've actually been less than honest and stated something that is demonstrably not correct.
Okay, well, that's a good start, Michael, in terms of getting a decision out of the ombudsman.
But I have to say that issue rested with the legal department, and I suspect that they were given. We think we understand how it's occurred, that the legal department were given information which they misconstrued and misapplied.
And then you've got Chinese whispers issues. Yes.
Yes, exactly. Yeah.
Yes.
We have pointed it out to them, but of course, Essex tend to be intransient on these matters.
Yes.
They regard themselves as big and powerful. So we wait hopefully.
Okay, so I've got one piece of information I want to tell people to finish.
Sorry, I'll shut up now.
It's fine. It's lovely to hear from you again too. The piece of information that I want to give people is that this week, it's not this week, it was about 4 weeks ago, the Ombudsman came out with a consultation about changes to a code of conduct for running complaints that the Ombudsman and the Housing Ombudsman have got together on. So I expect any of you who've ever complained know that there's a set of regulations about what the minimum standard of a complaint system is. But what the Ombudsman has done is get together with the Housing Ombudsman and write a more aspirational code for local authorities to comply with. And the key thing I want you to know, you can look at it online, is that aspirational on top of the regulations about complaint process, that aspirational set of instructions to local authorities or standards is all about giving reasons and expecting complaints officers to act independently and to give full reasons, not just to repeat the decision all over again. So it looks like there is progress, although it is glacially slow. And I would say that therefore, whatever becomes of CASCAIDr, and whether I hang up my podcast urge, whatever happens in the future, there is an improvement in the direction of travel. As the courts become less accessible because nobody can get legal aid, it looks like the Ombudsman is going to be the way forward. All right. So thank you very much for your attention today. Thank you for your question from Michael and Sheila. And the next thing that we look at is the fettering of discretion. We're going to look at why councils can't have blanket rules according to public law principles next week. All right. Thank you very much. Cheers.
Thank you.